Court of Appeal Division 1 is now in session.
Good morning. Please be seated. Thank you, Michael. This is the time and date set for oral argument in cause number CV190169, Yee versus Yee. These proceedings are being video and audio recorded as well as live streamed, so we ask counsel to please identify yourself and your client at the beginning of your argument. Each side will have 20 minutes. Appellant's counsel is responsible for watching the clock to reserve a portion of that time for rebuttal should you choose. Also, we've read the briefs, we've conferenced this case, we are familiar with the facts. Please take that into consideration during presentation of your case. At this point, counsel, you may begin.
Good morning and may it please the court. Trail Potter appearing for the appellant Karen Yee. To begin with, there are two issues before the court today. The first issue is a little bit cleaner. I'm going to address it regarding the attorney's fees that were awarded in the father's petition for a 529 child college account plan. This is a petition that was withdrawn on the morning of trial. And so,
Counsel, let's just start there. Wasn't it withdrawn on the morning of trial because disclosure of the funds in that account wasn't made until mere weeks before trial?
it was made on the requirement from Judge Cooper at the 30-day point, which all disclosures needed to be made. But to address why it took that amount of time, I think that unfortunately we have to deal with some facts that were absent from the record because of the withdrawal. The fact is this: there has been a lot of litigation between these two parties, including a lengthy bankruptcy. During that bankruptcy period, father had made inquiries, and there was email communication referring to Morgan Stanley accounts, MS, as it was abbreviated in the emails. So there was some discussion. Mother was under the belief that during the bankruptcy that this had been concluded or that there had been the appropriate exchange of information. But father's withdrawn petition specifically says UBS accounts. In asking mother if she had any UBS accounts, she honestly could not recall. This required us to subpoena UBS and get every possible account that was connected to the Yee family. This was over 90 days. It cost mother $500 and revealed that there were no UBS accounts ever held in her name. But to simply say there are no UBS accounts doesn't work. This is not the first couple in which one person has accused the other of having a hidden, undisclosed bank account somewhere. We were not able to settle this issue until we had brought in all of the UBS account material, all of the Morgan Stanley material, and then, as a solo practitioner with no staff, go through more than 1,000 documents to put together the actual picture. This took considerable amount of time, and once it was finally figured out where the money went in, where the money went out, and who had which accounts, it settled this matter. But the reason for all of this extra time was because father's petition specifically stated that there were UBS accounts held by mother. This forced mother to prove a negative. Proving a negative is difficult to do and expensive, but it should be noted that in the UAR of Judge Cooper, when she said that mother did things that it was impossible for father to do, that is not an accurate statement. Mother issued a subpoena to UBS Warburg, asked for every account that was listed under the children's name, and only when all of those accounts had been revealed and gone through was the full picture revealed that there never has been a UBS account ever held by mother. The fundamental basis of father's petition was wrong.
All right, even given that, had mother produced documentation confirming there was $20,000 on deposit in a 529 account, wouldn't that have been the end of the inquiry?
Only after this was all done did the father's counsel reveal that that was the end of the inquiry. It appears from a simple reading of the petition that father is asking about UBS accounts. He is specific and repeatedly says UBS accounts. Now, considering that the Morgan Stanley accounts were revealed in the bankruptcy communications, then that means that we are having to go on what turned out to be a goose chase. But we were following father's instructions. But more importantly, the basis of the award was on Rule 49. And Rule 49 says that D through K needs to be revealed. Well, D through J are all in anticipation of a modification of child support or establishment of these things. It is only under subsection K of Rule 49 where it talks about electronically stored information. But even then, Rule 49, which was the basis for the award of the attorney's fees, does not apply. Had Judge Cooper given another legal basis for the award, we could pursue that. But ultimately, this does not fall under a Rule 49 violation because this information simply was not available in response to the specifics of father's petition. It was not available at that 40-day mark under Rule 49. If I may continue, there is the second matter we have to go on to, which is the status of the reimbursements. Now, in this case, Judge Cooper's UAR, there's no question that the UAR is inaccurate. The UAR has errors. The only question is how much. To begin with, there are 3 orders in place. January of 2013, then a following January of 2015. Both of these established the use of insurance. There was later a decision by stipulation, unsigned and accepted as
Counsel, isn't an electronic signature a signature?
It is a signature, but it says accepted as signed. There is no sign here. There is no reason to believe that this has been reviewed or that it would fundamentally alter the rights of the parties in question. But
well, more to the point, I mean, you're saying, what's your suggestion there? It doesn't carry the force of law?
It absolutely carries the force of law, but it does not eliminate all prior orders.
And understand that. Well, go ahead, Judge Brown. What I struggle with is the qualification of how the July 15 order was signed. Why does that matter?
The issue with it is that there is the implication that it did not attain any kind of judicial scrutiny. But I
thought I heard you respond to Judge Brown's question as saying, no, it's valid.
It is a valid order.
So help me out again what distinction you're trying to paint, because I'm not getting it.
The distinction is that the July 2015 order did not eliminate all prior orders.
And I understand that, but how does that have to do with how it was signed?
We can move past how it was signed, and I can withdraw that argument to move us forward. The July 2015 order only addresses the issue that the proof of payment and how they are to be submitted. Just looking at the July 2015 order, which is the only order that is relied upon in Judge Cooper's UAR, it ignores the fact that the record shows 5 total quarters, no proof of payment was submitted. So even if we only look at the July 2015 orders as the standard by which the reimbursements could take place, an examination of the record shows that for 5 quarters, the father only submitted a spreadsheet with no proofs of payment, which are required. It's on page 2, subsection 7B of the July 2015 order. So by itself, we have error in the UAR by awarding essentially everything that he put in his ledger with no proof of those payments. Then we move on to the January 2015 order. This is a more robust order, providing a lot more detail. And this makes everyone's job easier. The appellee's reply brief acknowledges that the January 2015 order is in force and effect. Now, this order requires that father's insurance be used on every medical expense. Now, while it may say only medical, it's important to note that in that paragraph, it's specifically talking about psychologist appointments. And so the fact that father did not use his insurance, as it states in the January 2015 order that he must use his Blue Cross Blue Shield, the orthodontia has no evidence that insurance was used, and he admits on this record that no insurance was submitted for any of the speech therapy appointments.
Yeah, so let me ask you, paragraph 5 of the January 2015 order that you're referencing trails on about a page and a half. And it says sort of many things, and I will tell you, and sometimes in ways, for me at least, that are hard to reconcile. That paragraph seems internally inconsistent at times. Go ahead.
Acknowledging that this paragraph does seem to combine numerous subjects, it talks about specifics and generalities. The question, though, does this paragraph require that father's insurance be used? I think there's no place in here where it contradicts that, to says it is okay to take things, events, appointments that are insurable and simply not use insurance, that the use of insurance can be foregone without penalty. It does not say that.
My question was really somewhat different than that, and I understand what you're saying, is what if we have an order that the parties stipulate to that appears in material ways to be, at least in part, in conflict internally? Does that suggest we owe some deference to the trial court in what's required to comply with that order?
I certainly agree with that. We do owe that deference. But the problem we have is that in the trial court order, there is no acknowledgement that the January 2015 order even exists, or that any of these provisions, any ones that you can find, are enforced and should be applied to any current reimbursement, use of reimbursement or use of children's insurance. The fact that the 2015 order says that it must be used, and then the later stipulation that came in July does not address it at all, means that in this stipulated agreement, the use of father's insurance, and it says strong language, Blue Cross Blue Shield insurance must be used for all medical appointments.
It says that in paragraph 5. You're right. It says a lot of other things in
It
paragraph
does.
5 as well.
It does, and it goes on. But to look at this from the perspective of does this order consistently say the use of insurance? Moving on to the end of paragraph 6, this is at the top of page 6, the last sentence, both parties are entitled to review the insurance explanation of benefits to verify actual amounts paid by the other party. This entire order anticipates the use that insurance will be used, not just father's insurance.
Let's go back to that sentence.
Yes.
How do you view that sentence? What does it mean?
It means that insurance is anticipated as a part of all of the uses of appointments, of all.
But let's just look at the plain language. Both parties are entitled to review. So how does that apply to these facts?
The facts in this are that in this order.
And then I'll just cut right to my concern is when did your client request the explanation of benefits from husband?
She had requested them multiple times, but we're trying to get within the central fact.
The court specifically asked that question, or that was brought up, and there was no confirming documentation of the emails, except for 2 that were sent after the petition was already filed.
And we are not, our presentation here is not to argue those facts. We accept them as they were. But that father was required to submit mother's insurance as per the 2015 order. That was the central argument. What we have in the record is that father did have mother's insurance information and didn't use it. He simply refused. And so the reason why we are making this examination of this statement is to show that this statement anticipates that both of the insurance was still in a requirement for parties to use. This, combined with the last line, that any and all prior orders are still in force and effect, including the January 2013 order that says, very explicitly and a lot more clearly than the 2015 order, that both parties, if they have insurance, are to submit their insurance. And this is where we get the clean line that goes through them all. It is for the purpose of maximum coverage and to minimize the out-of-pocket expenses. The 2013 order states that both parties must use insurance. The 2015 order says that fathers must be used. These 2 paragraphs and the 2 statements can be read in harmony. Additionally, the 2015 order says that both sets of EOBs are available to be reviewed. We look at this as showing that this order anticipates that mother's insurance will also be used. There is the requirement of fathers.
Okay, let's back it up a little bit. So mother receives her first quarterly statement for uninsured medical expenses. There's nothing in this record that says she contacted father, she contacted the provider, she contacted anybody to submit her insurance to see if it would cover any of the expenses. Is that correct?
That is correct. But the record also shows that much of these expenses did not identify who the provider was. The example of the orthodontia, it's an American Express receipt. It doesn't give you any information and wouldn't be able to be used for any kind of insurance claim.
I agree with that, but the follow-up would be, did she contact father to find out A, who the provider was, B, why he wasn't using her insurance? I mean, did she put father on notice, I have insurance, you need to be using it? And if so, where does that appear in this record?
Yes, and in the record where it does appear is in the transcript of the record that father acknowledged, that mother testified that she had sent his information and that father also had it. We asked him directly if he had it, but did you submit any of mother's insurance? And he just answers no.
And I'm familiar with that in the transcript.
Mm-hmm.
What I'm asking you is this. That's father had the insurance card, father didn't use it. But what I'm saying is father sends mother the bills. Mother receives the bills. They're insufficient for her to submit on her own. Did she contact father and say, I need the names of the providers? I need the actual receipt for service. Did any of that occur when she first was put on notice that father wasn't using her insurance?
It did. The reason why the record is sparse is we had 90 minutes for this full trial. A good 30 minutes of it was taken up with the 529 plans. That leaves maybe 25 minutes for the testimony and to put things onto the record, of which there was a great deal of conflict. Because of the short period of time, and there was no grant of any additional time for this, that the record...
Did you make that request? You say, Your Honor, we need additional time. We have exhibits A, B, C, and D that we need to... You haven't had an opportunity to provide those?
Your Honor, I don't believe the record has that, but we...
And I believe in the record, Mother specifically says, yes, those communications do occur, but I don't have them with me today, or something to that effect, I believe. Is that your recollection?
That is my recollection as well.
So those were not disclosed?
We don't have those in evidence, but I think the evidentiary record here is sparse on a number of facts. We are missing everything on the 529 plans except for a little bit of testimony, and so unfortunately with this record, the total amount of disclosures, including 5 quarters worth of receipts, are also absent as well. And so there is a great deal of fact here that we weren't able to squeeze into that 90 minutes, and so we're working with what we do have. And that is that father did admit that he had all of Mother's insurance information, that he chose not to use it. So the question is the 2015 order that father is to use those, is to provide Mother's insurance, still in effect? Is that something that is active today? And I think that answer, when looking at the 2013 and 2015 orders, the issues about submitting insurance are read harmoniously. There is no conflict. There are other points in here, and admittedly the 2015 order kind of wanders around off the path, but it does consistently provide language that shows that it is anticipated that 2 sets of insurance will be used. More importantly, it does not specify at all that Mother's insurance is not to be used. This was a standard order, and one that simply makes sense. It's common sense to try and reduce the overall costs. And that doesn't provide any explanation as to why father did not use any insurance at all in several of the medical events, orthodontia, speech therapy, that are covered by insurance. There's no explanation as to why he simply refused to. If all the court looks at is the requirement that father submit his insurance, then already we have numerous errors in the under advisement record that awarded him the full amount of things that he chose to pay cash for and not use any of his insurance at all. Now, I have about 3.5 minutes, which I would like to reserve for rebuttal.
Thank you, counsel. When you're ready.
Good morning. May it please the court, my name is Mary Kay Grenier and I represent Martin Yee, who is not present today. I would like to start my remarks to the court today by indicating that I have a great amount of respect for Mr. Potter and his zealous representation of Ms. Yee. This has been a rough 5 years, and I have been there every step of the way and can tell you that Mr. Potter has defended Ms. Yee in a manner that she should appreciate. However, there is a distinct difference between zealous representation and flat disregard for the facts. And inadequate attention to the procedural mechanisms that would have been required of Mr. Potter to present facts and evidence in support of what he's arguing here today. Mr. Potter's job at the hearing, that it was a contempt hearing, was to be alert to and anticipate the defense that Mother would present. He didn't do that. He didn't file a counter petition to invoke the 2013 order as a counter petition for contempt, that father was in contempt for failing to present the 2013 order. He never even made a mention of the 2013 order by name, by exhibit, or by reference to the record during the trial. The 2013 order, dated January 14th of 2013, appears nowhere in the record.
Counsel, let me ask you, it wasn't a marked exhibit, but it's actually in the court's record, right?
True story. However, the cornerstone of his defense in the appeal is completely different from what his defense was at trial in the presentation of the evidence. After he had time to think about it, that's when he came back and said, oh, there's this January 2013 order that remains in full force and effect. And that could have been true, but that was never argued at trial. What was argued at trial was that mother asked father to submit things through her insurance, through EOBs, and he failed to do so. And that is just absolutely 100% untrue. That is why, and Judge Cooper stated to mother, you could have submitted whatever you wanted to your insurance company. That's not father's responsibility. Because the order was not before her, and the order was not argued, and the order was superseded, the 2013 order was superseded in January of 2015. Also another order that wasn't even mentioned during the hearing.
Would the January 2015 order have superseded in its entirety the 2013 order, or just is it your position for the purposes of this appeal that would be limited to the insurance provision?
Well, so let me back up for a minute and just make this offer to you. When I received the opening brief, there was a part of me that thought, I'm better off not responding and not answering this brief, because there are so many factual inconsistencies and disregard for what actually happened at trial in the brief, that my concern was in answering it and having to reformulate the statement of facts for this panel in such a way that they accurately represented what happened, and my reformulation of his arguments so that I could properly respond to them would do nothing but lend credibility to his argument, which is exactly what's going on here. The conversation that's taking place here regarding the January 2013 order and the January 2015 order were never discussed at trial. And had they been discussed at trial, they would have been debunked, they would have been set aside, and a proper conversation would have had with Judge Cooper regarding why the 2013 was not applicable and why certain portions of the January 2015 order were applicable to the 2015 order that was being enforced at the contempt hearing. So that is a long answer to your question, Your Honor. And we talk about number 5 of the January 15th order, and I'll direct you to lines 15 through 19 that says, father shall provide mother with a hard copy of Ryan's health insurance card. Blue Cross Blue Shield, which is father's insurance, must be used for all medical appointments, and mother understands she should never incur a cost pursuant to these terms. And the genesis of this order was because mother lost decision-making with respect to medical, dental, and vision care appointments for the child. She was left in charge of making therapy appointments for the child, but she had no ability to make appointments for the child unless father gave her the ability to do so. And one of father's biggest concerns is that mother would, there was a 3 or 4 hour hearing on this issue that resulted in this stipulation that father was adamant that mother not use her insurance card for obtaining the child's medical appointments, that his card would have to be used so he would be notified when mother was trying to make appointments or use insurance for the child. And this eventually, in 2016, led to mother's parenting time being supervised, and further orders of the court relative to, with respect to the youngest child, because mother was so inappropriate in the ways that she handled the minor child that in 2016 she lost parenting time to supervised only parenting time because of her conduct. This was just one of the steps along the way that transferred authority and decision making to father, and his was the only insurance card that was supposed to be used. That was 2015. So,
Counsel, what's wrong with Mr. Potter's argument about the purpose of these provisions read together, regardless of whether you look at 2013 or if you just look at 2015? Isn't there still an intent there or a purpose of maximizing coverage? And why wouldn't that benefit your client in every way? I mean, why wouldn't it also benefit your client to maximize coverage?
well, and it would have. And so the other response to Mr. Potter's argument is that even though he didn't present the 2012 order as an exhibit or a defense to mother's position, the tenets of that 2012 or 2013 order were discussed. First of all, the court and myself in cross-examination asked mother, just like the court pointed out earlier, the 2015 July order, the July 2015 order set forth the procedure for reimbursement and payback and notification of the bills. Father, exhibit number 20 is a thick exhibit. It contains each quarter that father submitted to mother, the proof of payment, the receipts that he had, and this information was given to mother on a quarterly basis. When mother said, "You never gave me the explanation of benefits so I can run it to my insurance company," both on cross-examination and by Judge Cooper, the question was asked of mother, "Did you ever ask father?" And she said, "Yes, I did." And I said, "Where is the proof that you asked father? Where's the proof that you sent a letter to me? I've been on this case since the very beginning. Where's the proof that a letter was sent to me, that an email that was sent to father? Where is that?" And mother's response was, "Well, I don't have them." And I believe she said, "I think I gave them to my attorney, but they're not here today." So let me follow that up quickly with then the next conversation that took place was the admission of exhibits, like subsequent remedial measure references to emails and telephone calls that mother made after being served with the petition to enforce, that she made to the providers, and an email that she sent to my client saying, "Where are the EOBs?" Well, that's delightful that you did that in February of 2018, but what about 2015 and 2016 and 2017, where she passed off those 2018 emails as a defense to her position as to why she didn't pay these bills in 2015, 2016, and 2017. So regardless of the fact that the 2012 or the 2013 and the January 2015 order were not specifically discussed at trial, which I think is a fatal flaw to this appeal, the tenets of those two orders were fully discussed, fully directed, fully crossed, and the court asked questions in order to get an understanding of why, to your exact point, Judge Brown, to your point, why isn't it reasonable that mother run them through her insurance? It is reasonable. And if you look at the remainder of the record, the court even contemplated whether or not EOBs should be included in a new order moving forward. And the judge said, Judge Cooper said, "You know what? I think this July 2015 order is fine because it doesn't say anything about what mother does with this information once it is submitted to her by father. She has the absolute right to take this information to the provider and say, I have insurance too. May I submit this to my insurance company?"
Let's talk about Exhibit 20.
Yeah.
Exhibit 20, it appears, or one of opposing counsel's arguments is that there are several quarters in which there is no supporting documentation, there are no receipts. How are we to, which I, from my point of view, that's a challenge to the sufficiency of the evidence. How are we to affirm the court's ruling on those particular orders without any supporting evidence?
Well, I believe the spreadsheet and the Exhibit 20 were consistent with the information that was provided in the bundles. I don't think there was a period of time where demands for money were made from mother to reimburse father, for which there was not at least some presentation of proof of payment.
Are you saying that just a number in the spreadsheet is sufficient under the July 2015 agreement, and isn't there need to be at least some semblance of a receipt?
No, I don't think a number on a spreadsheet is sufficient, but I don't think that took place. There was no number on a worksheet that was not accordingly supported by a bundle of receipts that was submitted to mother on a quarterly basis. I think what Mr. Potter's talking about is that there were times when father paid the speech therapist cash, and the speech therapist would write him a receipt for a cash payment. And he explained that fully in the record, that the speech therapist was not a coverable cost under his insurance. And so he explained it fully as to why that was a cash payment rather than a payment that he submitted to his insurance company only to pay an out-of-pocket expense.
On that note, how do we know, part of Mr. Potter's argument was that orthodontia and speech therapy were both paid out of pocket without insurance. How do we know that that was submitted to the insurance company and rejected?
So the orthodontia, I don't believe that was his argument. I think his argument for orthodontia was that it was by credit card receipt, and that was the only proof of payment that he made for the cost. And mother knew the child's orthodontist. I mean, it wasn't as though father was hiding behind a shroud of secrecy. And so, therefore, at the hearing, when the quarterly receipts were gone through in Exhibit 20 and the presentation of the credit card receipt for the orthodontia was provided, it was sufficient evidence that it was an out-of-pocket expense that mother was expected to pay. And moreover, there was additionally the sufficiency of Exhibit number 20 and the quality of the receipts was never an argument that was made at trial or post-trial. The only thing that father ever challenged was the cash payment for the speech therapist that was explained and the payment of the orthodontia by credit card. But the quality and the method of billing was never something that was challenged at the trial level. That was something that was new to the appellate brief.
But don't we have to be assured that the record supports the trial court's ruling? You have to specifically raise sufficiency of the evidence for the bench trial, and you have to file a motion for the trial?
No, but I would at least think that you would object to it. And I would object at the time that the Exhibit number 20 was offered in evidence, that there was an objection to the insufficiency of that as a representation of the billing practices that were the subject of the enforcement of the July 2015 order in the first place. That was not raised at trial.
That wouldn't go to admissibility, would it? It would go to on cross. If counsel didn't cross-examine, then that's one thing. But admissibility of the document doesn't mean you're admitting to the truth and veracity of everything in the document, is it?
No, but at the very least, there would have been a challenge raised at trial to the fact that one of mother's defenses was that quarter number 3 from 2015 didn't represent the meat of the July 2015 order in the things that it had to provide. Now, that would have been something that would have been a reasonable defense to make, possibly, at a contempt hearing. But at the end of the day, these are expenses that father incurred and paid for on behalf of the child while he had final decision-making over medical, and that he was the parent in charge of being the insurer of the child's medical care. And so while there was an expectation that father would communicate with mother what those bills were and the expenses that he paid out of pocket, he met that 100%. And it was quarter over quarter over quarter where there was no response from mother, no questions asked by mother, no queries indicated that mother was confused. Mother simply got on the witness stand and said, hey, I had the right to submit these to my to my own insurance, and that's my defense. And the court rejected that defense and said you had the opportunity to do that, you had the opportunity to have a meaningful discussion with father or his counsel by communication, and you failed to do that, and that is not a defense to properly submitted payment of unreimbursed expenses to the non-paying parent with the expectation that he would be reimbursed, which is the only thing that the court was considering on contempt, and the July 2015 order is the relevant order that the court was using to determine whether or not mother's behavior was contempt.
Counsel, you indicate that dialogue did not occur.
I'm sorry?
You indicate that dialogue did not occur. That
What dialogue?
When mother received these things, she didn't say, hey, I can't tie these to a specific provider or something like that. Correct?
At the time of the receipt of the bills.
What order set the deadline when she had to follow up? I don't see it.
So, well, there was no part of the July 2015 order that said that if mother doesn't follow up with father in a reasonable period of time. I would think that a reasonable period of time would be whatever period of time she needed to follow up with father so that she preserved her ability, if she chose to do so, to submit it to her own insurance. And so I would think in such a manner there has to be some self-policing. But and the fact that she presented a early, I think February of 2018 email at trial indicating that she knew exactly what to do when push came to shove. So she was served with the petition to enforce in early 2018. After being served with that petition and after I set forth everything that was going to be litigated in the contempt proceeding, she picked up the phone. She emailed providers and said, my ex-husband is suing me for out-of-pocket expenses. Can you help me? So we know that she knew what to do. But waiting till January of 2018 after she's served with a contempt petition does not exonerate her and rectify the errors that she made when she admitted to the court, I received these bills and I intentionally did not pay them. And so when the court reviewed the contempt and reviewed the evidence presented and the witness testimony, she made the decision that there was a valid July 2015 order that mother knew of, and she intentionally disregarded the terms of that order and failed to pay. And that's where the contempt finding came down.
All right, counsel, your time has run.
Oh, yes, it has.
Thank you very much
Yeah.
for your argument. We have 3 minutes and 20 seconds reserved for Mr. Potter.
Counsel, can I ask you one question as you begin, and it's with respect to 529. You mentioned the UBS was sort of mystical. Didn't the decree require or reference 529 UBS account?
Yes, Your Honor, it did, and it's confusing, but the decree was originally drafted by father's attorney. We don't know why originally these plans were created under a program called College Save. So where UBS came from, I don't know. Father did open UBS accounts, Mother did not, but...
And again, I don't want to dwell on it, but there is a commitment in the decree to 529 UBS accounts. Would you agree?
I would agree that it does say UBS.
Thank you.
However, arguments that the college saving accounts or the current collegiate accounts, which are completely intact and haven't lost any money and are all in place. But to briefly address what has just happened, a lot has been brought up to basically attack Mother's parenting or the history of this case, and not the facts that are before the case. What's at bar currently is questions about whether or not Father did do the proper submission of his expenses. Now, it was just admitted here two different arguments. One, that the original January 2013 order was never mentioned, but in the same breath that it was thoroughly argued before the court, that it was presented, and in the answer to the petition, while it doesn't mention it by name, it specifically says Father should have applied Mother's insurance. They were put on notice as to what the arguments would be. Admittedly, that answer to the original petition is anemic, but it's not deficient. It meets the standards of notice pleading, and it put them on notice that Mother's insurance and the submission of Mother's insurance was going to be the defense. It was thoroughly argued, but it was rejected for unknown reasons, because we do have two separate problems here, and they were conflated just now. The question of the absent receipts is one argument. That shows that the lack of receipts, the lack of evidence, means that providing this award is arbitrary. There was no receipts to back it up for 5 full quarters.
Did you waive that argument, counsel?
I'm
Did you waive that argument?
I don't believe that we did. And the places where we brought these arguments up, while they claimed it was not at the trial level, we did submit in the proposed judgment. Mother's proposed judgment, I believe that was document 416, lays out all of these arguments in detail, post-trial, with an examination to look at all the evidence that came through, to be able to provide, as it was called for, proposed judgments. In Mother's proposed judgments, we said, here's the amount that she should owe based on the actual receipts, not the spreadsheet. That is in the trial record. There's additionally, under document 417, another statement of facts and law which lays out exactly what these arguments are. They were fully briefed and are a part of the trial record. The second issue, there's the absent receipts is the first one. The second issue is Father's refusal to use insurance. As he says, he claims his insurance doesn't cover the speech therapy. No information was provided, no proof of this is provided. He chose to pay out of pocket, but in the record it shows that Mother's insurance covers that, even out of network, at 60%. And there's no explanation as to the orthodontia. It's a receipt. When he says he doesn't live in a shroud of secrecy, look at the receipts. They're heavily redacted. In some cases, they just say R. Lee. R could be the child, but R is also the first initial of his wife. So we're left with mysteries. And that's my time.
Thank you, counsel. We appreciate your arguments and the time you've taken and the attention you've given to this matter. At this point, we will take this matter under advisement. We will issue a written ruling in due course. At this point, we're going to take a brief recess to prepare the courtroom for our next argument.